I'm gonna ask Morgan Lamondre if she would come up to the mic that's right here, to the side.
Do I? Oh, excuse me.
And just let her add, yes, ma'am, right there. Yeah, I'll move it.
Senator, are we excused from the table?
No.
He's like, can I go home?
Just our restroom? Can I go to the restroom?
The legal degree is now having to ask, can he go to the restroom? You can go. You work hard.
Okay.
Women, don't try to run away from us. We'll be waiting.
Ms. Lamondre, would you please introduce yourself for the record? It may not be. Turn it on. What?
Thank you. Morgan Lamondre, I work for STAR, and I guess, Senator Jackson, I was hoping I could explain sort of the process as I knew it representing survivors in the old process and how confusing that was. And I am an attorney that represented a survivor under the new process. I think he said they did it twice. I represented one of those survivors recently. So starting with the old process, and as an attorney, Senator Jackson, it was the most confusing process to ever go through for LSU. I've represented survivors at various other institutions, and LSU had one of the most confusing processes. I did bring it to the attention of someone named Matt Gregory, who I believe was in the position before Jonathan Sanders, and Jenny Stewart before she was Title IX coordinator. And so let me explain how it worked before the Trump era regulations. There would first be a report, and there would be sort of the Title IX coordinator, once there was a coordinator, would look at the report and just determine if there's some sort of suspicion that, yes, this is a Title IX violation. And before the Trump revisions, it could be pretty much anything that would be sexual misconduct under the Student Code of Conduct. But you had PM 73, which was their report on sexual misconduct, like all of their policies. They also had their Student Code of Conduct. So it was like, okay, well, we have these two different like policies, but it was kind of the same thing. But the way it worked is the Title IX coordinator would look at it and be like, yeah, this falls under PM 73. It would be assigned to an investigator. An investigator would typically interview both the person who made the report as well as the person accused. Then the investigator at that point would determine if, by a preponderance of the evidence, that person was responsible. So in the eyes of most people who go through that, it's like, okay, well, my burden of proof, which is more likely than not, has been met. So my end of the process should be here. That was not the end. What would then happen is that whoever didn't get whatever outcome they wanted, so if it was the person was found responsible, that person could appeal. If the person was found not responsible, the other person could appeal. You could then appeal to the Title IX coordinator. The Title IX coordinator would then say, based on, I think you could only, I don't remember specifically what basis the Title IX coordinator would then get to reverse the appeal. But once that appeal happened, then they would say, okay, well, we're going to send it to the individual campuses. In my experience on the Baton Rouge campus, it would then go to student advocacy and accountability. Well, the student advocacy and accountability person would review the facts, meet once again with the victim and perpetrator, and for me, I'm like, at this point, there's been some sort of finding. They would ask questions of the victims and they would rehash details. I have never personally had a survivor that I represented with Jonathan Sanders, but one of my other attorneys has. They naturally do ask questions, and I think it's because after they ask questions, usually they'll kind of say at that point, okay, well, I think based on this process, I'm going to recommend to the perpetrator, and I'm using that language. They'll say, okay, deferred suspension, so kind of like a probation. You have to take some sort of class that good decision making, you have to get mental health counseling, something along those lines. But if the perpetrator didn't agree with that, then they could appeal to a hearing panel. The hearing panel rehashes all the facts. And
Wait, I'm sorry.
Oh, hold on.
Mike, how many, before you go to a hearing panel, how many procedures have you gone through?
so you've made a report. You didn't necessarily interview with the Title IX coordinator, but the coordinator reviewed it to see if there's some sort of suspicion.
Right.
So that I would still call that a process.
Right.
Then it went to the title, whoever was investigating. Until recently, it was what they called volunteers, more voluntold. And it could be the residential life coordinator. It could be,
So no one that was specifically trained to handle this.
well, and I want to be clear that they'll say that they were trained. They had maybe a training,
So
and
like we take a sexual harassment course for an hour.
it was probably something similar.
Yeah, I don't suspect any of us are ready.
The training would, in my opinion, and I think that there's a vast difference between learning about how to interview victims versus doing real investigations. And I can explain sort of
Right.
my critique of investigations there too. And it's not just LSU. I want to make that clear.
Right.
Also,
yeah.
listening on your phone.
But so to answer your question, then you've gone to an investigator, then you've gone to the conduct person. So at least sort of 3 processes at that point before the hearing panel.
So at each process, there's one person making a decision.
In each process, yes.
Yeah, because I know, and I've only represented one student at ULM, and it wasn't sexual misconduct. But I know we go from that dean, and we have to go through a panel after that.
Right.
But
right.
you're saying it's 3 different.
That's what was so confusing about it, because I set my.
Yeah, that's not every university. Because
No.
I'm telling you, I've gone through it with 2 students from ULM, and your one person panel is that first tier, and if you don't agree with that decision,
Right.
you go to a panel. You leave that person and you go straight to a panel.
Right. Well, and I can also get into how they're doing it now, but it's still a confusing process, because then, and I'll just hold on for that. But usually at other universities, it would be that there would be like a probable cause determination, and then you went to a hearing panel. You weren't finding your burden of proof each time. So that's what was, I remember emailing and meeting with them and saying it's not, as an attorney, it doesn't logically make sense that I have to meet my burden of proof so many times. Once I meet it, it should be met, the end. And so what would then happen is I've never seen, in my experience, somebody who was accused of sexual assault not appeal to the hearing panel, because what motivation do they really have? Because it's just, if they took that penalty, usually at that point, then they have to do whatever the penalty is. If they go to the hearing panel, it also delays time.
Right.
And so then you have to wait for a hearing panel. Survivors would then go through the hearing panel, and back before, there was no cross-examination. Essentially, the panelists would maybe ask questions. Once there was a finding, and I would say in the cases that we did represent survivors, there were findings of responsibility by those hearing panels.
So, like, let's say, and I'm going to direct this toward Mrs. Sanders because I'm trying to understand this. Sexual assault happens. That person is issued a punishment. I think it's by you, right? The Title IX finds that there is probable cause or justification. and you say you have to move off campus. Let's say that person appeals. Is there a stay?
It's a rehearing of the case, not an appeal, but
No,
to the
a
hearing
rehearing.
panel.
Is there a stay of your decision and that person gets to stay on campus while they appeal?
Yes.
So we have a sexual assault victim who stays on campus while they have a rehearing.
Per our Code of Student Conduct, unless they're intentionally suspended. We have worked on revisions to our Code of Student Conduct to remove that in our process, and that's not something that's been implemented yet.
Yeah, let me tell you what the court does. The court says that if a person, right, Jason, help me because you know this, right? That if a person is found guilty of something and punishment is implemented, that person also has to request a separate form, which we call a stay, of the punishment while that case goes up for appeal. And then you at that point who've heard it gets an or the court or you or whoever, or the appeals committee, gets an opportunity to say whether that person has a stay of the punishment. And what I'm saying here is that, let's say you say, okay, you did something in a dorm against a woman and you don't ever need to stay on campus again. Well, without that part of the procedure, you could seriously know at that point, this is bad. I don't care how this person appeals, this is bad and they don't need to be here. If you separated those two and made a person not only file a rehearing, but made them file for a stay of your decision, you are the hearing panel that's going to could make the decision on whether that person gets to stay on campus while they're appealing or having a rehearing. I think that's really significant because let's say you've heard it and you say, okay, yeah, you got a right to a rehearing, but we're not letting you stay on campus because the facts don't dictate that we don't move you off campus temporarily. Now, if your rights are restored, we'll save your room and we'll gauge it and all of that, right? Even we'll pick up your costs for staying off campus if you're found to be innocent at a rehearing. But I think it's very important that that person who you have believed to need to live off campus is not allowed to live on campus during a rehearing.
Senator Jackson, unfortunately, in this process, it gets worse. Once a hearing panel decision is made, and this was the old process, but unfortunately, I think it still might be the same process for this student code of conduct. I'd have to clarify. But then they could appeal to the dean of students. The dean of students gets to then say, uphold the decision or not. In my experience at STAR, they would uphold the decision. Then the person gets to appeal to the president.
Okay, let's talk about dean of students process because I'm going to go back and forth. I want to understand this. So you've said they're guilty. The panel has said they're guilty. So why does one person get to usurp a panel?
Why does one person get to, what was the last
Usurp the panel's decision.
SERP?
Usurp.
Usurp? Meaning to appeal, while they're appealing, they can remain a
To
student?
basically say, hey, I know the panel made a decision, but I see it a different way. Why does one person get to, and I know this is not your rule, but I'm just putting this on your mind. Think about it, okay? Why does one person get to override a panel? Am I making sense? Like basically, and I got to go with my career because it's all I know. We're before one judge when we go to district court. Then when we go further, we go to 3 judges. Then if we want to go to the Supreme Court and we're lucky to get there, we sit with 7 judges making a decision. There's never a point in the legal process, right? Well, do we sit with 7? We sit with 3, I think, right?
3 judges
3.
can overrule a jury.
Right, I understand that because they're judges and they have expertise and juries
But
are
a
lay
high
people.
burden.
Yeah,
High
with a high
burden to do
burden.
that.
And also, juries don't know the law that's being applied. But here, that's what I'm concerned about. You go to one person, then you take that one person to 3, then you go to another person, let's say the dean of biology. Unless you're telling me that they're like judges and the dean of biology has expertise in that area, right? You said they can go to dean of students, right?
Students.
Dean of students. So the dean of students has training in that area. How many hours does the dean of students have to have training in sexual assault?
I don't know.
Because this person has to be an expert if he can overrule everything, he or she. They have to be an expert if they can overrule a 3-person decision. There has to be some logic of why one person can overrule a panel of 3. And usually with the judges, it's because they have the expertise in law that lay people don't have. We get that. They've trained in law school unless you're going to give lay people the same degree of knowledge as you have in your degree, right? We get that. What I don't get, unless the dean of students has some expertise that we're going to assert today that makes he or she extremely qualified to overrule 3 people, why does it go to the dean of students with no panel? Am I making sense? And maybe the dean of students, can somebody tell me, maybe the dean of students is an expert in sexual assault. Maybe he or she, once hired, has to be trained to become an expert. Is the dean of students an attorney?
Not in my experience from when we represented survivors, no.
You get what I'm saying? Like, that's where I think, and I'm going to say this just in case that's still in place, that's to me a flaw in the process. And I want to make sense. And also, let me tell you what's the biggest flaw. That's when you get cover-ups. And let me tell you why I say that. That's when one person who walks that campus every day can be influenced by others. I thought the point of increasing the number of people who are hearing these cases is to make sure upon review that it's fair and equitable. You know, like when we go from the district court to the circuit court, we get like a 3-judge panel because one judge has already made the decision. So now we go to a higher court to see if those 3 judges differ. But you never go back to a 1-judge panel because every time the scrutiny of overturning a case gets higher. But here it seems like in the tiers that LSU had before you, because I know you're going to fix it, right? You're a decreer. And you guys have a great legal representation. I'm not saying it to be funny. You all have a great legal reputation in this community, and you've been fair and equitable. I've never seen you do anything egregious. That's a wonderful thing that people can say that about your family, right? And the flaw is this, and it's a big flaw, that you can go to one person who overturns 3 people. But we can't say on this mic, on this record, where that one person has any expertise that excels 3 people in a sexual assault, harassment, or rape case. Know what I mean? So that's something I'm going to ask. And I know we asking you to fix a lot of stuff, and you're probably like, I didn't know all this was going to happen when I got this job at LSU. I probably would have stayed in my firm. Seriously, that needs to be fixed. The appeals process needs to be simplified. And there should not be an automatic stay of an execution of a sentence by the person you put in charge while that person appeals. Now, whether we have to, and it's just like anything else that's done in the court system, if the decisions were wrong and the appeal process inures to that person's benefit and that person is found to be innocent, yeah, any financial things that they've occurred for staying off campus or whatever punishment should be restored to them. I don't even mind putting that in the law, right? I don't care if you have to carve out a special process for sexual assault cases. I think you should, right? I really do, because of the preservation of evidence that's needed in these cases. And I can tell you, if you're going through this whole process, and I know I'm rambling, you know I'm about the law, right? You are constantly like losing witnesses. People are getting tired. People are getting fatigued. And the victim finally says, forget it.
Yeah.
Especially in this situation, Senator Jackson, I would say it's exhausting for survivors. They're like, how many more times do I have to get somebody to rehash things, to be questioned? And if you survive the dean of students, you get to go to the president.
Another one-person
So,
panel.
Senator Jackson, what I think would be helpful,
Yeah, help
if
me,
you-
because I'm
if you-
rambling now, because it
if
all
you
doesn't
turn
make
to
sense here.
page 126 in this booklet you were given. It's
I'm
right
there.
before section 6. If you look at the left column,
Okay,
the far
yeah.
left column, you'll see below complaint, Title IX coordinator meets with respondent, supportive measures and processes. That's emotional support, LSU Cares, Lighthouse. There's only 4 more boxes: investigation, pre-hearing, hearing, and appeal, and it's over. That's where we are today, and how a complaint runs from adjudication through appeal.
So where we are now is,
If you look at investigation, there's only 4 boxes there: investigation, pre-hearing conference, hearing, and appeal.
Okay.
That's
So-
it.
So what about, okay, formal complaint is filed, okay? The notice of allegations are sent to the respondent, right? And then Title IX coordinator meets with the respondent, supportive measures and process. Let's talk about Title IX coordinator. Does the Title IX coordinator ever meet with the victim? Because it only says it meets with the respondent.
The supportive measures and process would be for the victim, is my assumption.
Okay,
I
so
don't think
that's
that
where the Title IX coordinator makes a decision or something?
No, the
I
Title
can
IX,
explain what happened recently.
the
if
Title
that
IX
helps.
coordinator doesn't make any decision until the appeal here.
Okay, so an investigation happens, I see it. And there's a pre-hearing conference, that's reasonable, that happens all the time. And then there's a hearing.
Yes,
Who's in that hearing?
it's 2 people plus an administrative law judge.
Okay, so now we've corrected it.
Well,
Okay.
do you have a question first, or?
No, just identify yourself since we're changing over. This is,
Oh, I had introduced
She
myself already.
introduced
I know.
Oh, Morgan Lamondre again.
Okay.
We corrected in the sense that the process of this chart is followed. I mean, I think maybe I was the second hearing this go around. I think because Jonathan was a hearing panel. So I don't know. He was a hearing panel member, and he did find the person responsible and expelled him, which is what I asked for. So that's good.
So
But
Jonathan was a hearing panel person with 2 others?
yes,
Okay, so it was you, the administrative law judge, and who else?
it was I think the dean of students,
No.
right? Or
It was,
DeLuca.
2 staff members, it was myself and another staff member from our department were the 2 other folks in addition to the administrative law judge.
So right now, how it stands, and this may be a good process, okay? It's the administrative law judge, yourself, and your staff.
1 staff member, yes.
One staff member, okay. So now we have a panel. That may work.
But it can be it doesn't have to be our staff. It could be other folks too.
Now, how do we determine who goes in that room with enough expertise and experience to hear these cases?
That's why the administrative law judge is a requirement from the Division of Administrative Law.
Okay, so is it a vote of 2 out of 3?
We're reaching consensus, so
Vote, does the majority vote?
however you
So
do that.
basically, those 2 staffers with very little to no experience, if it's, see, this is another, see, this is what we're gonna fine tooth it, okay? Fine tune it, I mean. So even though the administrative law judge is there, a majority consensus has to be reached for something to be implemented. So the 2 staffers that are sitting there can basically outweigh the administrative law judge. And I'm fine with that. I'm probably not having a problem with that. But I think we need to define what criteria has to be met for a staffer to sit on that panel. I think that, and so I want to work with you on that. I think it's a good process, but I think what's missing is because, and I get the majority, it's a serious thing. I think we need to define what training a staffer has had to have to sit on that panel. And I think those need to be designated staffers, like we do continuing legal education, that continue every year to be trained in this area. That would be my strong suggestion. And you may have 6 to 10 staffers per campus that are trained in that area, right? But I mean, I'm a biology teacher. If you can pick any old staffer, right? I'm a biology teacher, don't know anything about sexual assault, so I can get picked to sit on that panel. We still have a flawed process because the administrative law judge shouldn't be the one with all of the information. Because
Excuse me, I'm sorry for interrupting, but it's not necessarily the administrative law judge that has enough expertise, in my opinion, to actually be able to hear a sexual assault case based on what happened in the hearing.
And I get that, but I'll say
know.
this, and I'm gonna be honest. These elected judges, some of them never tried a sexual assault case in their life and never represented anyone. So
Right.
that's what you get with every judge in this state, because they're not, and I hate to say it, they're not fact specific, case specific, unless you're in family law and they become experts at it. But I know some family law judges never practiced family law till they got to the court. And I'm talking about the real court. And so I'm getting that. I hear it. And I think we could fix that. I think that because I want to not take this for granted. I think that may, and I don't know if we even have legislation left. I know I don't. May require legislation that says the administrative law judges that sit through these processes have to have the same training. to be eligible to sit through the process. And I think that fixes. I think also, Jason, we need to say, Attorney DeQueer, that we need to say, I called you Jason. I know, don't be mad at me, okay? That's what happens when all your brothers are attorneys. I think we need to say that these staffers who avail themselves to sit on this must have this specific training, and it should be offered every year.
Which I think that,
We have
as far as my experience, hearing panel members typically are trained. What they're trained about trauma, they're trained about how to ask questions. Sometimes they don't necessarily ask them in the most trauma-informed way. There's definitely more training on that. My concern as an attorney who went through the most recent process is the understanding of how to investigate correctly,
Right.
how to analyze evidence, and how to present. Because, and I mean, I think my client, would give permission, but obviously I know I don't have it with me. But I truly believe that had I not been there, there would have been a misunderstanding of the facts, because the investigation was very much not done in a way that I believe outlined the sexual assault. And what ended up happening is, I think I was able, because of the cross-examination, which a lot of people do not agree with, those new rule changes, and it's weird as a victim advocate to actually be a proponent of that. I'm a proponent of it based on what I saw in such what I consider a poor investigation. I believe I was able to recover and show that this was a serial perpetrator
Right,
who needed
right.
to be expelled, and I believe were able to do that. But I don't know if he could say it, but I believe that there are some deficiencies in how evidence is outlined.
Okay,
for
so let's
them to
talk
do
about
it.
the investigation. Who conducts the investigation in this new chart?
That would be the Title IX investigator.
So the Title IX investigator will never sit on the hearing, right? Because the person that's conducting investigation should not ever sit as a judge.
They shouldn't be a hearing panelist, no.
Okay.
They were like a witness in this proceeding, because they were asked to present their findings, and then we were able to cross-examine. When I say we, the respondent, the perpetrator, he had an advisor. I was also able to cross-examine the hearing panelist. What was weird in that situation is that the hearing panelist started questions first, and I was like dying, because I'm like, the way the investigation was outlined, they were having trouble understanding why certain things were not done, and I could see where the deficiencies were.
Yeah, I get it. I've taken enough time, and I can get very lengthy because this is but I think it's worth it so that people have a fair chance to have their cases litigated. I think we need to I like the new procedure, but I've made my recommendations on who should actually be sitting on panels, and that there should be requirements put in place, and that the administrative law judges, which we'll probably have to do administratively here because they're they're state employees, that they should have some type of training in this area before sitting on those cases, okay? I would say that this procedure needs to be put in place, Attorney DeQuitta, to go a little bit more judicially, where the panel is not asking questions first. I understand that first witness is necessary because they've investigated it, but I think both the plaintiff and defendant in that case, I know you guys call it something else, should have a chance to cross-examine, to question, and then the panel questions should come. But I'm really concerned that we need to put it in more of a format that gives everyone, because that may be the only court that student sees, or the only form of justice that person has had their day before that panel is well informed of the law, of procedure, and evidence. And however we need to get there, and I'm sure you know how. I can't suggest everything to you, but we need to get there. And we need to make sure those three people that are sitting there are able to properly digest and hear a case. Because what we may have is just three people sitting there, an administrative law judge telling them how to rule.
And Senator Jackson, one of the things though too that I do have concerns about, because with the new regulations, they make it to where Title IX is very specific. Title IX violations have to deal with whether it's on campus or it's a school-sponsored event. My fear is that if it doesn't fall under that, the default is still that old process. Is that correct? That is correct, right?
Correct.
So a student could file what would be a sexual misconduct complaint under the student code of conduct because it occurred off campus, has nothing to do with Title IX, but now they have to go through that old process that I explained to you. I'm pretty sure it's still the same
If it's
process.
a school event, though, it's included, right? Let's
School
say,
events, yes.
so
yes.
let's say we're
And-
playing
and-
as a Superdome, it should be included.
And one of the things, in Dr. Cassidy is here, is I believe the Office of Civil Rights in Title IX is going to handle all allegations of sexual
I
misconduct.
think that's what we need to do. I mean, we need a streamlined process.
I think that was the intent of creating that office. Although they wouldn't be Title IX, they would still, if it's sexual misconduct between students or involving students, it would go through that process. Obviously, there would be no jurisdiction between non-students.
But if it's a student, even if it happened off campus between students, it will come to you, right?
I think the intent is to go through that process.
So let's say we're traveling to a game away. That would still be
Title IX.
That would still be Title IX.
It's a
Because
school
it's
game.
school-sponsored
yeah, If
events.
it's a school game, yes.
Okay, so I'm good with that. So I think, yeah, we just, look, I've given my suggestion. I'm not long-winded, guys, but this has probably been something that's like an eye-opener. How many doors have been left open and windows for people to creep out of and get away with things? Not that that was your intention, but I think it's just a process. I think now cleaning up, I would like to see us become a model for other states. And when other schools are looking for processes that work and procedures that are in place that work, just like we were on the forefront of the USA Today for something bad, I would like to see 6 months to a year from now, USA Today, yeah, that we did good and that we corrected this and that there is a fair judicial process for these complaints going forward. And I know I've made a lot of suggestions. You may not take them all, but there are still some flaws in this process, right?
Yeah.
And we need to get to the point where there are no flaws in this process. Nothing's perfect, but the process we set up can be set up to work. And that's my strong suggestion. Training for anyone that's sitting on that panel. I don't want to go get someone that teaches chemistry to come in and decide a sexual harassment case. And I'm not saying that they're not intelligent enough, because juries decide them. But what I'm saying is they need a little bit of training, because I think that you lose the degree of just, when you're on a campus, right, that students should feel more protected than when they're on the street. And so I don't think it hurts that if we're going to, and I think that when the same people sit, it gives them a recurrence of what's happening. Also, it gives them more knowledge, right? And they know how to handle things better. But I don't want people, if my daughter or my niece had been sexually assaulted, because I don't have a daughter, but she spends my money like she is, right? If she had been sexually assaulted, I would not want her to go through a panel of 3 people that had no knowledge of what happens, the evidence, how to dissect it, how to digest it, and how to make a decision. And so and I think LSU has a chance to become a model at this, so other universities throughout our system and throughout the country can pick up on how do we deal with a sexual assault victim.
Thank you, Senator Jackson. Introduce yourself, please.
Hello, my name's Rachel Aber. I'm the president and CEO of STAR. I'm glad that the caller actually brought up this comment. So at STAR, we're working closely with LSU to fix these Title IX issues. But the issue is happening before students get to LSU. And so I do want to bring attention to sex education in high schools. That's actually something that's come before the state legislature for the past decade by former Representative Pat Smith, and that has not been supported by this legislature. And I think when we're talking about sexual violence prevention, it has to start with comprehensive sex education in schools. And LSU has done a lot wrong, and we can all look at the report and we can all sit here and talk about it. But if we're really talking about prevention, it's not looking at these processes. It's really looking at how students are coming to LSU and what education they've gotten before that. And so I just did want to bring that attention as something else the state legislature can do to help with this prevention focus. Because really, once students are at LSU, if you look at the statistics of sexual assaults that are happening, 50% of sexual assaults happening on campus happen within the first 4 months of the semester. And we know that freshmen are most vulnerable. So by the time they get to LSU, they're already at risk and they haven't gotten that education in high school. So I don't want to be very long-winded, but I just want to have the opportunity to say that because I think it is something that as a state we have to commit to when we're talking about prevention. Thank you.
Thank you. Thank you for that testimony. Thank you for sharing that with us. That's very insightful, especially to know that sexual assault actually happens within the first 4 months of them actually starting school. That's very interesting.
Yeah.
Okay, thank you so much.
Thank you.